Hey friends, welcome back again. I hope you guys are well and keeping safe. Happy New Year to you all and your families. And I hope you had a wonderful Christmas celebration and you were able to get some rest through the holidays. So first of all, before I get right into the video, I want to thank you all for sticking around with me, for your kind words, for the referrals, for trusting me to handle your immigration applications. I do not take it for granted at all. I appreciate it and I'm so grateful to you all. This year, I look forward to assisting very many more of you with your immigration applications and providing you with tailored advice to navigate your immigration situation. So again, thank you and happy new year to you all. So very quickly, I'm bringing you guys a very quick update. Yesterday, the government issued a policy memorandum titled Hold and Review of USCIS Benefit Applications Filed by Aliens from Additional High-Risk Countries. Now, you will recall that on December 16, the government issued a presidential proclamation designating 20 countries, an additional 20 countries as high-risk countries, in addition to the ones that were designated high-risk countries in June. So the December 16 presidential proclamation covered a total of 39 countries. Some were fully banned, some were partially banned or restricted. Now, this policy memorandum covers all 39 countries on the December 16 presidential proclamation. And now what is it saying essentially? The government says to place a hold on all pending benefit applications for aliens listed in the presidential proclamation 10/1998, which is the December 16 proclamation, pending a comprehensive review regardless of entry date. That means that regardless of whenever the applicant entered into the country, there's a hold on pending benefit requests. There's a hold right now. 2, conduct a comprehensive review of all policies, procedures, and screening and vetting processes for benefit requests for aliens from countries listed in the December 16 proclamation. Again, the government has talked about terrorist activities in some of these nations, corruption, and a host of other issues that the government has identified. So by this proclamation, the government is going to be conducting a comprehensive review of and screening process of all benefits benefit requests from aliens from these 39 countries. And then thirdly, conduct a comprehensive review of approved benefit requests implicated in Presidential Proclamation 10/998, which is the December 16 Presidential Proclamation, that were approved on or after January 20th, 2021. So in other words, the government is now going to be revisiting approved applications after January 20th, 2021. So we'll likely be seeing situations in the coming months where if a person has been approved for green card, the government will likely recall the green card if after this review, they find out that they should not have issued the green card in the first place because either the applicant withheld certain information that if they are disclosed during their application, they will not have been issued that green card or citizenship if the applicant is already a US citizen. Now, what does a hold mean? The government has defined what a hold is because a hold doesn't mean a full stop. The government has said a hold allows a case to proceed through processing up to final adjudication. A final adjudication refers to the issuance of a final decision on a case, such as an approval, denial, or dismissal. That means that a hold allows the case to continue. There's not going to be a full stop, meaning that, the government is not going to be doing anything because the hold is on. No. The hold allows the case to continue up until final adjudication. The only thing that will not be issued is a final adjudication, but the case will process up until final adjudication, meaning that the government will review the forms, they will do background checks, you will continue to do your fingerprinting, you will be called for interviews. So all of this will go on, but for the duration of this policy memorandum, which is 90 days from January 1st, there's going to be a hold, meaning that there will be no issued decision, either an approval, a denial, or a dismissal. So that's what a hold means. So the question comes, should I put in my application? By all means, put in your application because everything will go on as planned. Just that within these 90 days, there will be no final adjudication. Now, some applications have been exempted from this policy memorandum. Some benefit request has been exempted from this policy memorandum. And what are these benefit requests? Number one, the I-90 application to replace your permanent residency card. Now, interestingly, under the December 2nd policy memorandum, which covered applicants from the 19 countries designated in June before the government expanded that list on December 16, it also covered I-90. In other words, I-90 was also part of the applications that were put on hold on the December 2nd policy memorandum. But under this January 1st policy memorandum, I-90 is exempted from the hold. So I just thought to point that out. I-90 is exempted from the hold. N565, which is the application to replace your naturalization document, is exempted from the hold. N600, which is the application for citizenship certificate, is exempted from the hold as well. I-765 applications for employment authorizations filed under C8, C11 and C14. Now, it's very important that I explain this I-765 situation very explicitly. All I-765 by this proclamation are put on hold except those filed under C8, which is initial application for work authorization based on an asylum application. Now, renewal work authorization based on asylum is put on hold. Initial application is not put on hold. That's C8. C11 are those who were paroled into the United States for humanitarian purposes. Now, that is not put on hold. And C14 are those on deferred action. Deferred action means that the Department of Homeland Security has deferred the removal of the applicant or the alien, has deferred the removal of the alien from the United States. In other words, the alien is removable, but DHS has, in its discretion, deferred the removal of the alien from the United States. Now, those who are filing for 765 under these categories are exempted from the hold. All other categories of 765 are on hold. Now, I-90 application for civil surgeon designation. It applies to all applicants except those physicians who are citizens of the United States. Now, this means in simple terms, if you know that when you're submitting your green card application, you have to submit your medicals, which is done by USCIS licensed physicians, right? So if you are a physician that is not a United States citizen, you are not a United States citizen, then your application to be designated as a civil surgeon is put on hold for this 90 days. Now, benefit requests filed by aliens who is an athlete or member of an athletic team. I think that's self-explanatory as well. Benefit requests that are priority for law enforcement. Benefit requests filed by aliens who would serve national interests in the United States. For instance, the government has defined that to be like people who would come into the United States to carry out specialized medical research or scientific research, or an engineer with specialized skills needed for key infrastructure initiative, or someone with unique expertise supporting United States security and economic interests. So those are exempted. Those are under benefits for national interest, which are exempted from this hold as well. And then, of course, the government has said there's going to be automatic termination decisions for ancillary or related benefits when an alien is granted legal permanent resident status or becomes a naturalized citizen. Now, ancillary is like work authorization application, 765 applications, right? So if an applicant in the process of putting their green card applications, the applicant was already granted their green card, then the 765 is automatically terminated because that was an ancillary request tied to the main benefit, which is the green card application or the citizenship application, as it were. So the government is basically saying that there will be an automatic termination of ancillary decisions when either the green card or when an applicant has been given green card status or naturalization status. Now, this policy is effective for 90 days. After 90 days, the government would, after 90 days, the government, in consultation with the Office of Policy and Strategy, we'll put together a list for review, interview, or re-interview, and issue operational guidance on the way forward. Now, this is all that the policy memorandum covers. If you have any questions, please feel free to reach out. A lot is unfolding, and I understand that some of these things might not be clear, but that's why I'm here for you, to assist you, to provide clarity to you, and to help you navigate your immigration situations. Okay, I look forward to seeing you in my next video. Thank you so much, and stay blessed. Bye bye.